Hello everyone, welcome back to my channel. In today's video, we are going to discuss the Austin theory of sovereignty. So let's delve into it. John Austin, he was duration of his was 1790 to 1859. He was an English jurist and he's regarded as the founder of the school of analytical jurisprudence, which sought to analyze the nature of law, right, and sovereignty. He expounded his theory in his book on jurisprudence, and the book was published in 1832. His views had great influence on the lawyers, jurists, and writers on law in England and America, but they were severely criticized by the writers of historical jurisprudence and in the 19th century who refuted Austinian theory on the basis of history of law, state, and by the pluralists in 20th century. So he talked about legal positivism, he talked about social contract theory. Not he presented social contract theory, but his ideas was based on the social contract between ruler and the rule in a way that everything is ruler, and he promoted the idea of absolutism, and he was much into the legality of state. He was not talking about the popular sovereignty or the political sovereignty, but he was more into the proportion of legal positivism or legal sovereignty. So, Austin on law. Austin began his theory of sovereignty by first defining law. And what he says law is a command given by a superior to an inferior. What does it mean? In other words, it is a general command to do or abstain or refrain from doing certain acts issued directly or indirectly by the sovereign or the superior to a person or persons who are his inferior or inferiors in the sense that they are subject to his authority. What does it mean? Like, for example, if there is monarchy in a country or aristocracy in a country or totalitarianism in a country, most of their practice is that they uh, want or they wish that their public are subjected to them. Their public follows the rule which are set by or said by the ruler. So he somehow in sense of absolutism he made this legal system, right? So he distinguished between laws imposed by states, like positive law. There are many types of law. There are positive law, criminal law, natural law, constitutional law, and much more, based on moral principles. So, Austin said that laws are commands. What does it mean? That everybody has to follow it. It doesn't mean that like these laws are only for a group of people who have to have obey these laws. No, according to Austinian theory on legal sovereignty, laws are regarded as commands. Everybody has to follow it. So these are the laws of sovereign enforced by sanctions. If no one is following the law completely or partially, then they are going to have some punishments, or if they follow, they are going to have some rewards. So he talked about legal positivism in sense that Austin's legal theory stressed the importance of positive law over natural law, morality, and justice. So you can search the video of mine of legal positivism. I will link in the description below. Austin on sovereignty. Austin defines the sovereign or the superior in a state as thus that if a superior human not in the habit of obedience to a superior receives habitual obedience from the bulk of given society. That determines superior is sovereign in society and society is politically independent. He further then added that to that determinate superior to other members of the society are subject or on that determinate superior to the other members of the society are dependent. What does it mean? It means that um, according to Austin, people, public are dependent of sovereign, the ruler. People are subject to the ruler. They have to have follow the instructions of the ruler. There is no way that they can deny that I'm not going to follow your commands. You have to, right? So this is the thing Austin is describing in terms of sovereignty of the ruler. So sovereign authority is in the hands of ruler, and for Austin sovereignty is the ultimate power to issue commands and force obedience. Like, for example, when we talk about parliamentary democracy, so in parliamentarian democracy, the people are sovereign, right? So it is written in the preamble of the Constitution of United States of America that we, the people of United States of America, like it starts from the we, the people of United States of America, right? Which means that they are holding people sovereign, like people have the ultimate authority, not the government, not the rulers. But in this case, in the case of Austin's theory, ruler is ultimate sovereign, ruler has the ultimate authority. Legal versus political sovereignty. Austin distinguished between legal sovereignty, which is obviously based on law, and political sovereignty, which is based on power. So sometimes what rulers do, that they negate laws and they just try to capture as much power as possible. So they forget about the welfare of the state, they forget about their public sometimes, or they forget everything. They are just in the lust of power. So in this situation, Austin is discriminating or distinguishing the differences between legal sovereignty and political sovereignty. That legal sovereignty is based on laws, like ruler has made laws which everybody has to follow. And in case of political sovereignty, uh, power belongs to the ruler, political power belongs to the ruler. He in this case he can accumulate as much wealth as possible because he has the power. He is not following the law, he can do corruption, he can capture the taxes of public which public is paying. So this is the thing. Yes, in terms of legal sovereignty, in terms of implementation of laws, Austin's theory is considered to be very, 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 important. That Austin made sure to implement laws, but somehow critics, they criticizes that he went too far in the implementation of legalities, that he forget moral principles, he forget natural principles, you like that. So ultimate authority is in the hand of sovereign. He distinguished between legal and political sovereignty, and then he described unlimited jurisdiction, which means that Austin's theory posits the sovereignty of a state are possessing unlimited power within its jurisdiction. What does it mean? Like, for example, a ruler has an ultimate authority, and a ruler is much more authoritative, and he is imposing laws and he is making sure that law and order should be followed in his country. Now, the thing is that he cannot implement or impose laws outside his territory of his country, outside his state, outside his border. He just has to implement his laws uh, within its own jurisdiction, right? key concepts of Austin theory. Only a sovereign person or a group of person can have ultimate authority. They can be sovereign, which means that not a lot of people can be sovereign. As Rousseau describes that sovereignty cannot belong to the general will. The concept of general will is that if a thing is beneficial for public but not in the favor of you, then you have to prefer the general will as a ruler. So this concept sovereignty cannot be implemented. So a group of people or a single person can always be a sovereign. Second one, the power of the sovereign is legally unlimited or absolute, because the laws which he makes are obeyed by all, while he himself does not obey any law. Hence, there can be no limit to his power. He makes his own limits. Legally speaking, the sovereign is, almighty by law. The third point is sovereignty is indivisible. If sovereignty is divided by law between two or more persons or bodies of persons, then one of the two things would happen. Either one of them will limit the authority of the other and thus become the real sovereign, and the other person in the body of persons who has legally implemented authority of others would become legal sovereign. So the sovereignty cannot be divided. One person has this right to, you can say, exercise the sovereignty. Fourth key concept of Austin theory. State is such a society which is organized by rule and obedience. A law is a command calling for obedience, and state exists only when there is sovereignty and subjection of obedience to the law or command of the sovereign. So sovereignty is as necessary in the state as the center of gravity in the mass of matter, because without law, without rules, everybody will seek their own benefits. There will be no concept of law and order. So everybody has to obey laws. Criticism of Austin theory. According to some critiques, the Austin theory of sovereignty does not apply on existing states, which means that many philosophy or philosophical scholars have criticized Austin philosophy as overly simplistic and reductive and does not apply to existing states. When confronting with the problem of pointing out the determinate human sovereign in an existing state like England, Austin was unable to give a clear cut answer. Instead of it, he variously replied that Parliament is sovereign, or in the electorate is sovereign when Parliament stands dissolved, etc. But obviously, this answer has not the clarity of his definition, because once he's saying that ruler is the sovereign, and when questioning about England he is saying that Parliament is sovereign. So there is no clarity between his answer, and it includes that astounding assertion that electorate is sovereign, although it cannot at all be a determinate body, as of Austin's sovereign must be, right? Second critique, criticizes that failed to distinguish between political and legal sovereignty. Some argue that Austin theory does not address the comparison between legal and political sovereignty. His theory is an attempt of a lawyer to give a lawyer's view of sovereignty, because he, like Austin, was the founder of analytical jurisprudence, which he sought to analyze the nature of law, right, and sovereignty. And he wrote the book Jurisprudence, and he was the proponent of legal sovereignty. So, from his point of legal sovereignty or sovereignty, it can be seen that simply a lawyer is making the concept with the lawyer's point of view, not from a political point of view, not from a popular point of view, not from a public point of view. It is a theory of uh, legal sovereignty, right? And he was right, therefore, when he said that king in parliament is sovereign. Obviously, in parliament, king is the sovereign, but uh, in according to his theory, the parliament itself is not sovereign. He is regarding king in the parliament as sovereign, but when he tried to include the electorate in it as well, because it elects the member of House of Commons, he failed to keep in mind that it is not legal sovereign because it cannot make laws, right? And at the same time, legal sovereign, uh, which according to him is king in parliament, is not absolute because it is conditioned by a number of influences and forces which constitute political sovereignty. The third criticism Austin theory of sovereignty faced is that the theory is opposed to popular sovereignty and laws of nature. It is pointed out by Sidwick Clark and Richard and others other that Austin theory is inconsistent with the idea of popular sovereignty. It also ignores the public opinion, disregards with general will, as I told earlier. Austin's sovereign has the support of force alone and not for the will of people. Like his center of attraction, his center of point is the sovereign, the ruler, not the people. So he's not talking about the popular sovereignty. He's just confined towards the legal sovereignty. No part of Austin theory is more severely criticized than his conception of law as the command of the sovereign, because according to him, the command of the sovereign is absolute, and it is not advisable in current world order that uh, like conception of law or the commands of sovereign are not the ultimate. You have to have include the popular sovereignty. For instance, Lasky says that to regard law as the command of the sovereign is, even for the jurist, to strain definition to the verge of decency. And Austin's conception is attacked on the two ground, historical and sociological. Alternative theories of sovereignty. There can be legal monarchism, there can be popular sovereignty, there can be divine rights of theory. I have made a video on divine rights of king, which I'll link in the description, and I have talked about a lot of of popular sovereignty in this video, that this theory holds the people are the ultimate source of political power, and that the government exists to serve their will. So the government is not the sovereign, but the people are. And then there is legal monarchism, which means that this theory posits that the sovereignty lies with the individual who holds the highest rank in legal hierarchy, such as monarch or the judge. So there can be a bit similarity between the Austin theory of sovereignty and the legal monarchism, but they do not resemble completely. So what is the conclusion of Austin theory of sovereignty? Austin's chief error was that he laid too much stress on one aspect of sovereignty, which was the legal aspect, right? And he excluded all other influences and forces that determine the nature of law and sovereignty. He excluded popular sovereignty, he excluded political sovereignty, he excluded the you know electorate system of parliament. And this was the like natural for a lawyer who was interested in lawyers view of sovereignty, right? So he was not seeing sovereignty as a whole, in a circumference of every aspect. He was just seeing with one aspect. But for the political philosophy and science, it is like too narrow and too abstract because he's concentrating towards just legal point of sovereignty. And nevertheless, Austin's theory of sovereignty has certain merits and some value. It provides a most consistent juristic thought of sovereignty. It is a logical exposition of the monistic view of sovereignty, right? So, if sovereignty is strictly viewed as a legal concept, Austin's theory, as the government remarks, is clear and logical, and much of his criticism is based on misconception and misapprehension. Like, if we are, regarding just the legal aspect of sovereignty, then the Austin theory of sovereignty is the best one. But if we are seeing sovereignty as a whole, then there are a lot of flaws in it. Limitations: Austin's theory does not apply to existing states. He failed to distinguish between legal and political sovereignty, opposed to popular sovereignty and law of nature, ignore the right and freedom of voluntary association, and he says that independence is not characteristics of modern states and states are externally independent. So that's for today for Austin theory of sovereignty. See you tomorrow.